Hello friends, lot of debate on issue of a notice under section 148 of the Income Tax Act 1961 was going on. Whether the notice issued after 1st April 2021 are valid or they are not valid. Honorable Delhi High Court recently on 26 August 2021 has granted the stay. Writ petition was filed stating that department cannot issue the notice after 1st April 2021 under the old regime of the Income Tax Act regarding Section 148. Learned counsel for the petitioner states that the impugned notices are invalid in the eyes of the law and void from inception as they were issued without following the process of issuing a prior notice under Section 148A of the Income Tax Act. He submits that the impugned notices are invalid as they have been issued under the pre-amended provision of the Act, which were no longer in force on the date of the impugned notice. He stated that the amendments are applicable to all the notices issued under Section 148 of the Act post 1st April 2021. He also relied upon the interim stay orders passed by the Bombay High Court as well as the learned division bench of the Honorable Delhi High Court in the case of Mohan Kohli dated 7 July 2021. And the learned counsel for the respondent states that in the present case, the time for issuing the notice under Section 148 of the Act stood expired, and therefore any action under Section 148 would have been time barred by virtue of the provision of Section 149, subsection 1 of the Act. They submit that by virtue of introduction of Section 3, subsection 1 of the Taxation and Other Laws, Relaxation and Amendment of Certain Provision Act 2020, the time limit for taking action under Section 148 has been extended till 30th June 2021. According to them, the impugned notifications only provide that as per time limit for issuing notice under Section 148A of the Act has been extended by deemed fiction, the procedure to be followed till 30th June 2021 would be the old procedure mentioned under the Act. In support of their submission, they have relied upon Section 6 of the General Clause Act 1897. Consequently, following the interim order passed by the division bench in Mohan Kohli versus Assistant Commissioner of Income Tax, dated 7 July 2021, as well as similar interim order passed by the Bombay High Court, the Honorable Delhi High Court directs that there shall be a stay of the operation of the impugned notice dated 9th June 2021, 30th June 2020, and 28th June 2020 passed in writ petitions 6442 of 2021, 6443 of 2021, and 6451 of 2021 respectively. Now, the Honorable Delhi High Court said, till further orders, the respondent abstains from continuing with the reassessment proceeding in any manner pursuant to the impugned notice. And next date of hearing is 28 September 2021. Let's see what the decision comes. But in the meantime, another judgment of Honorable High Court Chhattisgarh dated 23rd August 2021 has come. In this judgment, they held that the notices issued till 30th June 2021 under the old regime in respect of notices under Section 148 are valid. This order was passed on 23rd August 2021, the Honorable High Court has taken a view that due to the COVID situation and the limitations to perform certain act has been extended, and and in likewise situation the principle as laid down in the case of A.K. Roy versus Union of India reported Air 1982 SC 710, the Supreme Court held that the Constitution 44th Amendment Act 1978, which conferred power on the executive to bring the provision of that act into force, did not suffer from excessive delegation of legislative power. The court observed that the power to issue a notification for bringing into force the provision of a constitutional amendment is not a constituent power because it does not carry with it the power to amend the constitution in any manner. Likewise, in this case, the delegation to the executive with the power to the general with the central government to specify the date by way of relaxation of time limit, the main purpose of the Finance Act is not defeated. They said the Honorable High Court of Chhattisgarh, under the circumstances by the notification, the operation of Section 148 of the Income Tax Act was extended. Thereby, deferment of Section 148A was done. It was done by the Ministry of Finance by way of conditional legislation in the peculiar circumstances which arose during the COVID and lockdown, and central government cannot be said to have upon turf of parliament for sake of brevity. Both the notifications are produced. They have produced a notification dated 31st March 2021 and another notification 27th April 2021, and they have said further a reading of the aforesaid notification would show that it was issued in exercise of powers conferred under the Taxation and Other Laws, Relaxation and Amendment of Certain Provision Act 2020, and time for issue of notice under Section 148. The end date was initially extended up till on 30th day of April 2021 and subsequently again by notification dated 27th April 2021. The time limit of 30th day of April 2020 was further extended up to 30th day of June 2021. By effect of such notification, the individual identity of Section 148, which was prevailing prior to the amendment and in certain of Section 148A, was inserted and saved till 30th June 2021. The Honorable High Court is of the view that by way of extension of the time limit in view of the Taxation and Other Laws, Relaxation and Amendment of Certain Provision Act 2020, Section 1 of Section 3, the time limit was extended. Therefore, they said, likewise, certain right which was reserved in favor of the Income Tax Department was also preserved and was extended at partially. Consequently, the provision of Section 148, which was prevailing prior to the Amendment of Finance Act 2021, was also extended. Hence, in this case, the power to issue notice under Section 148, which was prior to the amendment, was also saved and the time was extended. In the result, notice issued on 30 June 2021 would also be saved. Therefore, no interference is required to be made in the said issue of notice, and accordingly petitions are dismissed. Now, the situation at this stage is that notice issued under Section 148 of the Income Tax Act up to 30th June 2021 in respect of the prior regime before the amendment, as this Honorable High Court held, those are valid. Let us see what the decision of the Honorable Delhi High Court comes on 28 September 2021. Thank you very much, friends.